Welcome, folks. Thanks for joining me here today. In December of 2020, the newly elected City Council attempted to clean up our parks and waterways. We did this by enforcing our anti-camping laws. Unfortunately, at that time, a group calling themselves Legal Services of Northern California sued us and halted this process. Due to a federal court ruling known as the Martin v. Boise, Idaho case, we were forced to enter into a settlement agreement as the only means of clearing our public spaces. In turn, we opened the pallet shelter, now called Genesis, and the alternative site at Eaton and Cohasset Roads. We began cleaning and clearing different areas throughout the city of Chico: Tykert Ponds, Comanche Creek, Depot Park, and Lindo Channel, as well as other areas. As we moved forward, we continually faced more legal challenges and hindrances from Legal Services of Northern California. The city of Grants Pass, Oregon, facing a similar issue, pursued a path which led them to the Supreme Court of the United States after years of litigation. We supported their efforts through what's called an amicus brief. Finally, we got a decision from the Supreme Court, and they wrote clearly and plainly that local ordinances and laws regarding camping in public spaces can be enforced and addressed. In the opinion, they actually cited issues from here in the city of Chico and our circumstances during that time that we faced during our attempts to clean up our public spots. This decision brought and garnered praise from both sides of the aisle. Governor Newsom even said, "Today's ruling by the U.S. Supreme Court provides state and local officials with the definitive authority to implement and enforce policies to clear unsafe encampments from our streets." This decision removes the legal ambiguities that have tied the hands of local officials for years and limited their ability to deliver on common sense measures to protect the safety and well-being of our community. On July 9th, I called for a special closed session meeting of the Chico City Council so we could discuss this opinion from the Supreme Court and what impacts it would have on the city of Chico. Council acted as I believe best reflects the desire of our community. We asked to enter into a new agreement with Legal Services of Northern California. This agreement would provide enforcement consistent with state, local, and federal laws following the Grants Pass decision, and would immediately allow us to clear waterways and parks and public spaces of encampments. It would begin a slow close process of the alternative resting site at Eaton and Cohasset Roads, and it would continue the operation of the pallet shelter with new rules and regulations through the end of the original term. The city believes that the benefits of the pallet shelter are worthy of continuing, as it provides a strong pathway for homeless to live and connect with state and county services. With the change in the law and this definitive ruling from the Supreme Court, we believe what we offered is not only fair, but the right thing to do. If a new agreement can't be reached, the city will move forward to seek judicial relief pursuant to Rule 60 of the Federal Rules of Civil Procedure. What does that mean? In short, it means that if we can't get the new agreement, we will seek to exit the agreement in its entirety. This community must see an end to the abuse of our parks and waterways and public spaces. We must see the close of the alternative site at Eaton and Cohasset Road and the issues which have plagued it for way too long. And we must continue to offer a helping hand to those who seek to exit homelessness through a positive pathway. This solution is reasonable, logical, and fair. The solution is measured and reflective of the Supreme Court's ruling, but is also reflective upon what I believe the majority of the citizens of Chico want. I'm asking you, the citizens of Chico, to join the council and join the community and support this path forward. Thank you for your time today.